And the people are represented by Mr. Bruckler, Mr. Orman, Ms. Pearson, Mr. Edson, and Ms. Tish McGuire. The record should reflect that we are outside the presence of the jury. In terms of the people's request for an additional in-camera review of the records that were produced by the University of Colorado pursuant to PSDT and PSDT2, I conducted that review over the weekend, and I'll be issuing an order later today. Is there anything we need to take up outside the presence of the jury before we bring him in on behalf of the people?
No, Your Honor.
On behalf of the defense?
Yes, briefly, Your Honor.
Go ahead.
Your Honor, we anticipate testimony at some point this week from some crime scene investigation witnesses that we would like to move and eliminate to exclude pursuant to rules 401, 402, 403, state and federal due process, and the state, Mr. Holmes' state and federal rights to a fair and reliable sentencing proceeding. First, we're anticipating that fingerprint examiner Sandra Fisher is going to be testifying either today or at some point this week, and that the prosecution is going to offer her testimony concerning fingerprinting the deceased victims and her efforts to conduct, to find matches, fingerprint matches, and to identify the deceased victims, including obtaining prints from them while their bodies were moved into the hallway or the lobby of the theater, locating exemplar prints from databases, including a military exemplar print from Mr. Larimer, that Mr. McQuinn's mother had to come and identify him in person because they weren't able to locate an exemplar print for him. Our position is that all of this testimony regarding the efforts to identify, testimony that goes to identifying the deceased victims in this case should be excluded under 401, 402, 403, state and federal due process and state and federal right to a fair and reliable sentencing proceeding, because the identity of the victims and the deceased victims in this case has already been established primarily through the testimony of Detective Matthew Ingwe, who was the witness who introduced some photographs of the deceased victims in the theater and referred to all of them, the ones who were located in the theater by name. We've also had some testimony from first responders who encountered and tried to assist other deceased victims, Ms. Mosier-Sullivan and Ms. Gowie.
So if your argument as to why you're objecting to the evidence that you've outlined, then I understand. I get that. But to the extent that that was intended to be an objection to the officers getting emotional, that's untimely. There's nothing I can do about that. Now, in terms of the objection, what's the people's response? Mr. Orman?
There are a number of objections there, Your Honor. The first one was to having Ms. Fisher, a criminalist with the Aurora Police Department, testify that she identified victims through their fingerprints. I haven't heard anything in any of the cases cited by counsel that indicates that is some type of improper or inflammatory testimony. Certainly there are numerous ways in which the identity of a homicide victim can be established and that we can do that. I haven't seen any cases that say there's exclusively one and one only that can be done. I think the jury in this case is entitled to know the procedures that the police went through to conduct their very thorough investigation at the crime scene relating to the firearms, relating to the other evidence, and relating to the victims. And the care that they took in processing the crime scene, the care that they took in identifying the victims, the care that they took in preserving evidence of the crime. I think that counsel described that as upsetting. The fact that fingerprints were taken from dead bodies is upsetting, and therefore I guess that means it's unduly prejudicial under 403. I think that's the argument. The upsetting thing is that the defendant went into a theater of innocent people and shot them. Right? The upsetting thing is the defendant shot a little girl. That's the upsetting thing. The upsetting thing is the crime. The criminalistic procedures utilized by the police to take fingerprints off of the victims, I can't see being upsetting under any stretch of the imagination. It is not like she cut off their fingers or something. She took fingerprints in a way very similar to the way you take fingerprints off of someone who is still alive. And I can't imagine how anyone finds that upsetting. I think that the objection should be overruled. Also, Ms. Fisher would testify to some other things that are beyond the scope of this, but I don't hear an objection to that. Regarding the other issues, Your Honor, I think I've discussed why we would want to present evidence as to how the crime scene was processed, and that's really what they're objecting